Be ready for FATCA webcast. We're delighted so many of you could join us today. Just to let you know that your phones will be on mute, but also if you could just mute them. We have had some slight technical problems with the muting system here, so if you could mute them during the call, that would be great. We will be open for questions. You can ask these using the chat function, and we will take those questions during the presentation. Obviously, we will be sending out this webcast will be recorded, so we will be sending out the link to the webcast at the end of this presentation to everybody. At this stage, I'd like to hand over to Alan Cohen. Alan.
Thanks, Steve. Yes, well, welcome to Be Ready for FATCA, the webinar sponsored by Thomson Reuters. We're very excited today to have our speaker. Foreign account compliance, FATCA, and the far-reaching impact of it globally has been a large and complex issue around the world. We're very fortunate to have Martin Michaels, an international expert in the field, with us for discussion. Martin is a prolific author of tax publications and represents clients around the world. He is a partner at Baker McKenzie in Zurich, Switzerland, and I believe he is making his call today from Asia and maybe some of the issues that we're having technically here. Martin is an author of many authoritative articles, including articles in Journal of Taxation, Journal of International Taxation, and one of his publications include a very popular commentary called International Taxation Withholdings, and his new 2013 edition is out and available, pictured here on the screen, and of course this is also available online through Checkpoint and Checkpoint World. So with that brief introduction, it's our distinct pleasure to hear from Martin Michaels on how to be ready for FATCA. So with that, Martin, please take over.
Thank you. Thank you, Alan. This is Martin Michaels. Greetings from Hong Kong. I am unable to use the WebEx, so I'm going to call out the page changes as I'm making them so that they can be heard during the presentation. I am also unable to receive questions on the WebEx, so you'll have to email them to me, Alan, so that I can get them on my BlackBerry in order to respond accordingly.
Sure.
So I'd like everyone to turn to page 5 on the slides. That's the slides that you passed out earlier today. So what we're going to start with, and we have roughly 40 minutes to discuss this, is discuss a little bit about FATCA for those who may not have so much familiarity with FATCA, but also for some of those of you who may. Now, when the FATCA notion came into being in really 2008, but was finally enacted into law in 2010, the concept behind it was that U.S. tax law for various years had allowed for mismatches, which allowed for U.S. persons to hold assets outside the United States in a way that if they wished not to declare them, it could be held in a way that they wouldn't be declared, such that they could evade their appropriate U.S. tax obligations. Now, when these rules were designed, the rules that existed prior to FATCA, most of these rules were designed in a time when KYC, or Know Your Customer rules, were in their absolute infancy. Now, by that I mean that most of the rules that we had that really are even the rules that apply even now were designed in the mid-1990s. Hard is it to believe that when these rules were developed in the mid-1990s, the notion of what we consider Know Your Customer rules and AML rules were really in its infancy. The U.S., in fact, I would argue, for the most part, didn't even have any significant rules. In fact, the rules that they had at the time were so basic have any way of looking for people behind structures. The reason being that prior to the events of September 11th, 2001, the U.S.'s rules for determining who was behind a structure were very infantile. So as a result of that most of the rules as they existed were based on U.S. tax principles. Now, U.S. tax principles look to who was responsible to paying the income tax on the asset, and that's it. And that related to cause certain situations where account holders could in fact have an account abroad and not disclose it in the U.S. And without any violation of relevant U.S. rules. In addition, the rules at the time, which I believe were a correct and accurate statement of the rules at the time, were such that it only required reporting on U.S. source income. So if an American outside the United States with relevant institution, it wouldn't be a disclosure. If I were to say FATCA in one word, it would be mismatch. FATCA is designed to go after situations where U.S. tax law wouldn't have forced disclosure if an American had assets overseas, and as a result could keep money undeclared inappropriately. So what was FATCA? The purpose of FATCA was designed to allow the world to work in a way that it would force disclosure. In effect, what the FATCA rules do is they impose a default withholding tax on three different types of income. The first type of income is what is called reportable amounts. The second type of income is called gross proceeds. And the third type of income are called pass-through payments. Now, each of these types of payments, as from the effective date of FATCA, trigger a 30% withholding on each of these things. Now, with the first payment, which is called a withholdable payment, which is a reportable amount, is what we would traditionally call in the non-resident alien world non-resident alien withholding. That is income from U.S. source, interest, dividends, rents, royalties, etc. The second type of payment is called gross proceeds. Gross proceeds is what happens when you sell shares of some form or another. So use the following example. You buy Microsoft for 100. You sell it for 50. Even though you've lost half of your value, you'd still have a withholding of 30% of the 50 remaining. Pass-through payments is a concept which, quite frankly, I'm going to skip for the moment because rules don't come into effect through 2017. It's a very confusing topic. We will come back to this in a few minutes, this concept, but the whole concept is that the withholding tax will be applied unless, A, you're a natural person and can prove you are a U.S. person or can prove that you are a non-U.S. person, and if you're a U.S. person, you disclose yourself. B, you are an active business, or what we call a non-financial foreign entity, or C, you are a foreign financial intermediary, which we'll talk about, which has elected to be a participating foreign financial intermediary. If you're not one of those three, this withholding tax applies. Now, whether or not it is correct or incorrect, as a practical matter, at this moment in time, with the U.S. still being roughly 40% of the world's equity markets, the U.S. can legislate by capital markets. Now, historically, when these rules were proposed, I personally thought that these rules were using an atomic bomb to kill an ant. However, as these rules are evolving to be a system by which many countries can share information, perhaps someone who would advocate the automatic exchange of information could be something that could be interesting. Now, on this front, I'd like everyone to turn to slide 6, FATCA, where we are now. In 2010, the FATCA rules, which were enacted as part of the HIRE Act, came into law. In theory, the rules should have been effective January 1, 2013. Because the FATCA rules are so complicated, They were delayed and delayed. We had some draft regulations issued in 2012 where people had the opportunity to comment, and there were more than 200 comments. Earlier this year, we actually had quote-unquote final regs issued, subject to further changes, and the notion is that the rules should have come into force with a slight delay on January 1, 2014. This has now been delayed a further 6 months, and there are still many, many open issues with respect to FATCA that the U.S. Treasury is trying to clarify as we go on. I would like now to turn to slide number 7. Okay. In the context of FATCA, the world gets divided into 3 classes. Class A are U.S. persons. Class B are non-U.S. persons that are flesh and blood. Class C are entities that are neither U.S. persons nor flesh and blood. If you are a U.S. person, a term which we will discuss in a few minutes in any event from now, you're exempt from FATCA. If you are a non-U.S. person and you are flesh and blood, you are also exempt from FATCA. Where FATCA affects primarily is entities. Now, the world gets divided into 2 types of entities. The first are what are called foreign financial intermediaries, or FFIs. The second type are non-financial foreign entities, or NFFEs. Now, FFIs are in effect any type of legal entity that when it is holding the asset, it is holding the asset on behalf of another. An NFFE is any type of entity that when it receives income from an asset, it is holding it on behalf of itself. Depending upon what you are, whether you're an FFI or an NFFE, will in fact influence how these rules work. The bottom line is the U.S. is far less concerned with NFFEs than
Martin, I think we lost your audio. All right, okay, we lost
Hello?
your audio there for a second. Yes, we hear you now. Thank you.
Hello? Hello?
Yes, Martin, we can hear you.
Can you hear me? Can you hear me?
Yes, we can. Yes, we can. Continue.
Okay. So I would like everyone to turn to slide 8. Slide 8 is a flow chart which is designed to work as to what someone is or is not. If you are an FFI, the default position will be any payment that is made to you will be subject to withholding tax of 30% on FATCA income or reportable amounts, gross proceeds, and what will eventually become in 2007 pass-through payments. In these cases and in these instances, there will be 30% withholding. That will be the law unless you elect to do one thing, and that election is to become a participating FFI. That is, you agree to take on other obligations with the U.S. government that you wouldn't otherwise have. Now, I have had the question over and over again, well, I just don't have any U.S. payments. What do I care? I'm going to stay out of this because I don't have FATCA income and I don't have gross proceeds. Well, yes, that may be nice and fine, but as a practical matter, the banking system freezes for you if you are an FFI when these rules become effective, because no one that has elected into the status will risk their status by doing business with someone who is not a participating FFI. Now, at this point, I'm going to skip slide 8 and ask everyone to go to slide 10. Slide 10 is a slide that says FATCA as part of U.S. tax law. Now, for this purpose, I think it's important that we understand that FATCA is not in a vacuum. FATCA works in the context of U.S. tax rules. What FATCA is designed to do is look for U.S. indicia, meaning things that would indicate who is a U.S. person for tax purposes, using things that would indicate that you are a U.S. person. Now, for this purpose, what's important to understand is that the definition of who a U.S. person is quite different than most other places in the world. A U.S. person is defined as a citizen. So a U.S. citizen is someone who is a U.S. person automatically. It doesn't matter where they live. It doesn't matter if they've renewed the passport or not. They are a U.S. person first or foremost. And there are some rules that make people U.S. persons that they don't even realize. The first is if you're born in the United States, you're automatically a U.S. person. The second is if you have one parent who's a U.S. person and they spent 14 out of their first 18 years in the United States, even if they give birth to you outside the United States, they're a U.S. person. Another person who is a U.S. person is a green card holder. Someone who holds a green card, irrespective of whether they live in the United States or not, is a U.S. person, subject to some limited exceptions. Some green cards have expiration dates. What's important to note is even if the green card expires for immigration purposes, it's still valid for tax purposes. And residence due to physical presence. This is a mathematical test applying to people who are not citizens or residents but spend a lot of time. Also, there are other concepts which we will not talk about today, dealing with entity classification and check-the-box rules, which could be a whole discussion by itself, the treatment of certain types of trusts, also outside the scope of today's discussion, which affect these issues. Now, I'd like to turn to slide 11, which is who are FFIs. Now, an FFI is a defined term. There are 5 different types. The first is a depository institution. This is an institution that accepts deposits in the ordinary course of banking or similar businesses. In this definition also includes a trustee who is a commercial trustee. A custodial institution is any institution that 20% or more of the entity's gross income is attributed to holding financial assets related to financial services. An investment entity, and by the way, a custodian is someone who holds equities or shares. An investment entity is, in effect, anyone who is in the business of acting as an investment manager or some form of fund in the business of investment management. Specified insurance companies are insurance companies that have products that have a cash value to the products. That means that if the product were to be redeemed, they would be redeemed for a fixed cash value. And certain holding company and treasury companies, these are holding companies or treasury companies within groups that have purposes other than holding assets for the group themselves. Now, when you look at these 5 terms, at least the first 3 of them, you would say, why do we need to define these words in this format? And my response to that would be, in order to understand that, you have to understand the way the U.S. thinks. In most parts of the world, a depository institution, a custodial institution, will be the same institution. Even an investment entity will be the same institution. We normally just call them a bank. In the U.S., since the 1930s, with Glass-Steagall, these types of institutions were broken up into different types of banks in order to, quote-unquote, preserve the financial system. Now, so these rules are drafted this way. At the end of the day, it just makes the rules more confusing for others. Now, the specified insurance company rules, these apply because of a perception that certain people were holding assets in offshore insurance and not declaring it to the U.S. because they said they didn't have a legal obligation to. FATCA cures that problem. Certain holding companies and treasury centers. This has to do with the fact that even though there are certain treasury functions of corporate groups that operate like a bank, so long as it's working for a corporate group, it should be outside the scope. However, certain of these entities actually, in fact, hold themselves out to the public to do certain treasury functions, and in addition to that, they may do it for other companies. And in those cases, they created special rules. It should be noted that the draft regulations only talked about 4 of these, and that they added the 5th as the regulations were finalized. Now, I'd like to turn to slide. I'd like to turn to slide 12, which is phase-in of FATCA withholding. Now, the bottom line is these rules are extremely complicated, and the financial institutions around the world were asking for as much time as possible in order to make this implementable in a timely fashion that was in a timely fashion that made it work. Now, what's important here, and it's important for everyone to understand here, is that the critical point is that when you look at the history of all the implementation of withholding tax systems in the United States over the course of the last 20 years, the U.S. will implement the rules. But when they implement the rules, they recognize that these are very complicated rules for financial institutions. And so what they'll finally do is they'll implement them, but they'll say, we have a transition period. And during the transition period, if mistakes are made, no one looks too hard, and no one gets punished too difficult, in a too complicated or too difficult way, in order to make it work. We have this transition implementation phase at this point. If you look at slide 13, key dates, these are the dates that are starting to occur in the course of the next year, which are relevant for the progression towards implementation of FATCA. The first of those dates, and by the way, the charts on slides 14, 15, and 16, 17, and 17, 18, and 19 go into these in more detail. So what I'm going to ask everyone to do is I'm going to ask everyone at this point in time to please look at slide 14. Slide 14, it starts with 2013. Now, on August 19th, the portal, meaning it's a fancy way of saying the website, which is the system by which someone who wants to register as a participating FFI went live. Now, what's important here is, while it is live, on the one hand, it is not able to register. It's a system by which people can practice. You can practice now. You can save your information now. However, you cannot actually register under the system until such point in the system as January of next year. So that's where we are for now. Nothing can be done until January of next year. Now, if we turn to slide 15, that's 2015. On January 1, 2015, well, in theory, 2014, in theory, you can finalize the paperwork that you started last year so that you can start the process of being registered with the IRS as an FFI. When you register with the IRS, you will get what is called a Global Identification Number, a GIN. That will be a way that everyone knows you are participating in the program. Now, in theory, you can register at any time. However, what becomes critical here is there will come a point in time where during this system, if you are not in place and up and running by a certain period of time, most institutions will start to withhold on you sometime next year. And the IRS has stated that, at least for now, that date is April 25th, which means you have to have registered by April 25th in order to comply, in order to be available and listed as a participating FFI on June 2nd. The significance of that date is the first effective date under FATCA is June 30, 2013. Now, when this date occurs, this will be the date that if you have someone who you know is a U.S. person or has indications and they will not allow their disclosure to the U.S., withholding is supposed to occur. As of July 1, the new rules start. You must start the process of documenting your clients. You must start the process of identifying who the account holders are and working towards reporting. Now, the withholding occurs during this period of time, and that will continue through the end of the year. This is the first date. The other significance of July 1 is that there is a notion called grandfathered obligations. Now, grandfathered obligations are certain types of debt instruments and other types of instruments that were around before that date. They will retain their character of being outside of FATCA. Now, the important thing for this is these rules should have come in a couple years ago, and they've allowed the extension until this date. I would like everyone to turn to slide 17. Now, on 2015, we see the beginnings of the system becoming more and more important. In January 1, certain types of withholding payments start again. The first reporting under the FATCA system for 2014 will occur for non-U.S. persons, which is pooled reporting on March 15th, and for U.S. persons at the end of the month. You will have to report substantial U.S. owners in certain cases, and then middle of 2015, further withholding will require, and then a process by which not only can you rely on someone providing information to you, but you may have to double check. Then let's turn to slide 18, which is 2016. Again, the significance of this year is, in many respects, nothing really changes, but this will be the first year that you're really working as if everything's supposed to be up and running. And then if you go to slide 19, we mentioned pass-through payments a couple of times. That's something that is still to be developed, so we should be leaving it alone. One thing I omitted on slide 2016, that in 2016, that's the first year that withholding on gross proceeds starts. Now, I would like everyone to turn to slide 20. The real purpose of what you're supposed to be doing with FATCA is you're supposed to be looking behind structures, behind various different accounts for people who would have indicia of U.S. person status. These are people who, they're not saying they are U.S. persons for tax purposes, but the information that you find may indicate that they have indicia of being a U.S. person. Such indicia are identification of the person as being a U.S. citizen or resident. So, for example, if you have a passport or an identity card, and it says place of birth, New York City, that's an indicia that would indicate the person's a U.S. person, absent them being able to prove to the contrary. Another example would be an address in the United States. If you have that, that is an indicia. A place of birth is an indicia. And in care of address or hold mail address, which is sole address on file. In other words, if someone's saying, please hold my mail or send it to my friend's address in Germany, and you have no other address, then the default is they're a U.S. person. If a lawyer in the United States has a power of attorney on an account for a Venezuelan client, that is an indicia until you can explain otherwise. My two favorites are the following: standing instructions to transfer funds to an account maintained in the United States. What I love about this one is how many people have kids going to university in the States and they send a monthly transfer for the beer money. Well, absent knowing something to the contrary, all of a sudden, that's an issue that you're going to have to overcome. Oh, by the way, a U.S. telephone number. That's my favorite, because today telephone numbers don't represent anything. Telephone numbers just represent a phone number. However, if you have a number that indicates a U.S. cell, then all of a sudden that's an indicia that needs to be overcome. Now, indicia of U.S. status does not mean you are a U.S. person. It solely means that it's an indication that you have to ask, why are these things in play and what needs to change? Now, we've already talked a little bit about the FATCA portal, so given the time constraints, I'm going to skip slides 20 and go to the blank slide 22. Now, a review of forms. I want to mention that in the vocabulary of this new FATCA system, there are a whole host of new forms that are created. There's a form W-8BENE, which entities will disclose themselves. We have new forms that are called 8966s, in which you're going to report U.S. persons. We have new uses for forms that already exist, like Form 1042 and 1042S. I could spend an hour and a half just on these forms. I will just point out that these forms are in draft form now. To the extent that you're going to be looking at these things, it is worthwhile to take a look at them now, because they will change, but they're not going to change too much. Now, slide 23, I'd like everyone to turn to slide 23. I would just like to mention here that I kept on saying here that the default is if you are an FFI, you're going to have a withholding. The only way you get out of withholding is if you elect to become what is called a participating FFI or PFFI. In these cases, what that institution does is they take on further obligations to identify their account holders, figure out their indicia, do extra due diligence, do extra reporting, do certain reporting in certain cases, and certain compliance to ensure, as part of this process, that there are no U.S. persons and that they will report all relevant U.S. persons, even if they have no U.S. income. Why is this relevant? Well, let's go back to the rules as designed in the year 2000 under the qualified intermediary regime. Now, the rules as they existed then said if you had an American and they had an account with old Hong Kong Bank and they had no U.S. investments, there was no reporting. That was probably a correct statement of the law at the time because there was no law to change it to make it more broad. FATCA says that no longer works. Also, because of the way the rules worked at the time, the QI rules, as they were designed at that time, also said if an American were to have their assets in a BVI company, even if they held U.S. investments, if the company was respected and there was a business reason for the company to exist, there would be no disclosure. But having said that, one's KYC rules would in fact cause situations where there would be disclosure, where the bank would know there was a U.S. person behind the structure, and this was designed to deal with this. Now, I'd like to briefly turn to slide 24, and in the context of slide 24, I'd like to just briefly mention this concept of expanded affiliated groups. Now, expanded affiliated groups is a concept that is a direct result of how the prior system worked. Banks would make the choice under the old system that certain bank subsidiaries would participate and other bank subsidiaries were not, and that you could create, in fact, an institution could pick and choose a system that as they worked and how they worked, they could manipulate the system to ensure that every American could be with them without any disclosure unless they wanted to be disclosure. The expanded affiliated groups say if you are part of a larger group, if you have one entity that is a foreign financial intermediary and elects to be a participating, that everyone in the group needs to elect. In other words, no more picking and choosing, no more creating systems that could potentially get around there. At this point, given the time constraints, I'd like to skip slides 26, 27, 28, 29, 30, and I'd like to just go on to slide 31 for a second. Now, so far, we've been talking about the fact as how this applies to financial institutions. So I'm sure there's some people on the call saying, oh, I'm not a financial institution. I don't have to worry about this. I can go along my merry way. However, the way the rules are drafted, what we're finding is, in fact, the contrary is true. There are many institutions, particularly those who are using things like royalties or are with employee share plans or had M&A spin-offs in which their financing arm is now financing a third party, or have an entity within the group that does financing for third parties, that all of a sudden find themselves caught within the FATCA rules. And one of the most interesting meetings I heard about FATCA in the last year was a tax director of a Fortune 500 company said they had not even contemplated this, and yet something like 13 or 14 subsidiaries out of 165 companies would technically meet the definition of FFI, and they hadn't even contemplated it. So if you are an industrial company, this is also something you need to contemplate. Now, at this point, I'd like to switch to slides 32, 33, and the like thereafter. Now, given the time constraints, I'm going to not go through the slides slide by slide, and I'm just going to express the concept. Now, the concept is that the U.S. is imposing some extraordinarily draconian rules, imposing, just by virtue of its capital markets, the ability to force people to compel to behave all around the world. Now, these rules, the problem with these rules are that, in fact, many of these rules violate home country rules. So, for example, in more than a dozen countries, there is some form of bank secrecy, and I'm not talking about jurisdictions like Switzerland, Belgium, Luxembourg, Austria. I'm talking countries like France. I'm talking countries like Brazil, where there has been a history of abuse by governments of banking information, so that there's a secrecy, so that there's an issue. So there needed to be a solution to deal with those issues. In addition to that, most countries have prohibitions about enforcing foreign country law on home country soil, which makes sense because you don't want to be having those types of systems. Further, the U.S. also realized that getting cooperation from governments to participate when banks would have to be trying to enforce rules in laws they didn't understand, in systems they didn't understand, dealing with a governmental agency where they didn't have it, and quite bluntly, because the U.S. didn't have the manpower to make these rules work in any way, shape, or form, they created a notion called intergovernmental agreements. Intergovernmental agreements are a system by which, A, depending upon the system you choose, the rules will shift from being a U.S. issue to a home country issue, or B, there will be a relief from certain of these draconian rules depending upon the agreement you enter into. The bottom line is that there are two models, Model 1 and Model 2. A Model 1 agreement is effectively an agreement in which another country agrees to implement FATCA into its own domestic law. It then ceases to be a U.S. issue and then becomes a home country issue. Now, when it does, it's supposed to model itself on U.S. rules and adjust accordingly. Now, in these cases, the institutions subject to FATCA then report to the home country, and then the home country reports to the United States. Now, in the context of FATCA, there are two types of Model 1. Model 1 reciprocal means that the U.S. is supposed to also exchange information back to the home country, in theory. Model 1 non-reciprocal means the other country just provides information to the U.S., with the U.S. not providing any information back. Now, most institutions prefer this. Why? Because they know their home country laws, they know their home country regulators, they know how to deal with these issues, and they don't have to deal with the complexity of global institutions of an extremely complicated nature and an extremely complicated structure. And so, in fact, most of the world is going to Model 1. Now, in certain cases, either home country rules make it impossible to implement a Model 1 agreement, or the government has chosen that they don't want to deal with it in some way, shape, or form, then in these circumstances, countries can elect Model 2. In effect, Model 2 implements the FATCA rules, the rules, and as a consequence of this and entering this agreement, the U.S. agrees to liberalize their rules as part of this system in order to make it work. In other words, through this system, through this process, it makes it easier to work. Is there anything else? Is there anything else I can help with today? Are there any questions? Can anyone hear me?
Hi, Martin. Thank you very much. Yes, we can hear you. Thank you very much. We do have a couple of questions come through. Alan, are you on the line? Can you repeat the questions? Okay. Well, you can ask questions. If you do have any, you can ask questions through the chat function, which is on the right-hand side of your screen. So please fire any questions you've got for Martin over. We've got a couple of questions come in from Bharat Bagani. So let me just ask those questions, if that's okay, Martin. He was asking about is there no reporting obligation for non-FFIs, i.e. if they do not meet the definition like 20% of their income? You may have answered that question subsequent to the question being asked, but it's about reporting.
If you're not an FFI, there's no reporting. If you're not an FFI, there's no reporting obligation.
And again, we also had a question about the date that FATCA will be implemented.
FATCA implements over a period of time. As discussed on the call, it is a phased-in implementation. The first effective date is June 3rd. Is July 1 next year.
Okay, thank you. We'll just give us an opportunity for everybody to ask any more questions.
Yes, Martin, can you hear me? This is Alan.
Yeah, we can hear you, Alan.
Okay, yes. A few other questions here. In terms of the IGAs, how far along are we in developing these IGAs, and how and the impact of that?
Well, the U.S. is currently negotiating about 80 IGAs, including places like China and India. Quite frankly, I don't think we are as far along the process as I would hope we would be, but we are actually rather far along the way. If you look at the chart, you actually have a chart on slide 37 of ones that are either signed or being negotiated, but there's at least 80 that are currently in process. And I would say most of the EU jurisdictions at this point are pretty much all in some way, shape, or form in process.
Someone was asking a specific question about an agreement between the US and the United Arab Emirates. Martin, any news on that?
To be very honest with you, I'm unaware of any negotiations one way or the other, so do not take this interpretation as a positive or a negative.
Okay. A question from Bernard Tucker. Typically, who in the organization will be the responsible officer?
The responsible officer will typically be someone in the legal or compliance department who will undertake the responsibility of making sure the system works.
So that'll be different for different organizations based upon how they're...
Yes, it's whoever in the organizational structure makes sense. Yeah.
Thank you. And a question from Kareem Mohammed. What is the link between FATCA and I'm not sure I understand this, QI, WP, and TP.
Okay, FATCA is a new set of rules that apply. FATCA is a new set of rules that apply, governing a whole new set of systems from the new rules. All the other things were designed were some form of mechanism under the old rules dealing with allowing the U.S. government to modify the requirements for obtaining information and reporting.
Thank you. And I think the last question we've got time to take right now from Simon Chatterton. What are the chances of the whole system collapsing or going under heavy changes if IGAs cannot be signed with the key outstanding jurisdictions?
I understand where you're coming from. I understand the thinking, but after the G20 resolution over the weekend of a agreement that there be automatic and spontaneous exchange of information within the next 2 years, I think FATCA is going to be the mechanism by which everything actually gets done.
Okay, well that's unfortunately all the time we've got for any more questions. If you do want to ask any more, we will pass these on to Marnin, and we will get back to you by email after the event. I'll hand back to Alan right now.
Yes, thank you. And want to remind participants here that the slide deck that you've seen here on screen in its full form will be emailed to all of you. Also, Marnin's book is available from Thomson Reuters, as well as it's available electronically online through an online service, Checkpoint World, where there are content sets regarding planning, withholding rates, and a variety of research content, as well as the ability to have a new FATCA content set available. So feel free to reach out and contact the folks here. And again, thank you to Marnin for an outstanding presentation, and we look forward to further conversations.
Thank you. Bye.
Thank you.